नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Now, this is something that we discussed briefly in the last class as well, and we'll be continuing with the same discussion. So, just briefly to summarize what is basic structure about, we discussed several aspects of basic structure. The first being, why is it that basic structure doctrine evolved, and what led to the development of basic structure doctrine in India. As we discussed in the last class, basic structure doctrine is primarily about determining the one important question, that is, who is going to be the final arbiter of constitution? Who is it who will decide, which wing of the government will decide what the constitution is about? Now, I gave you the example of the discussion on Article 21 of the Constitution in the last class. And we discussed that how when there was a discussion going on with reference to Article 21 and specifically with regard to whether the term procedure established by law should be used under 21 or due process of law, the Constituent Assembly members seemed to argue that we are not going to insert due process of law under Article 21 because that would amount to giving judiciary the power to review all the actions of legislature and the executive. And the primary power to determine what the law, what the constitution is, must reside with the parliament per se, or with the legislature, and not with the judiciary. And that is why the text of the Article 21 that we have in the Constitution features the term procedure established by law and not due process of law. Now, obviously, subsequently, over a period of time, Mishra versus Union of India being the highlight moment, watershed moment, wherein there was sort of a complete disjunct from how Article 21 was and why Article 21 was inserted under the Constitution by the Constituent Assembly, and what Menka Gandhi case argued or held was that Article 21 talks about due process and it is not just procedure established by law. But the only reason why this example we discussed in the last class was in order to understand that since the process of formulation of Constitution itself started, we were discussing this very core issue about who should be the final arbiter of power, whether it should be the judiciary or it should be the parliament per se. And the Constituent Assembly seemed to tilt in the favor of not of vesting this power with the parliament instead of with the judiciary. So eventually, over a period of time, as we discussed in the last class, a series of specifically different laws were being passed by the state. Now, those laws were made with different intentions. Some of the provisions and amendments were also made to the Constitution. One of the amendments being that in case under Article 31, being that in case a law is passed by the Parliament to implement directive principles of state policy, such a law would not be challenged for violating fundamental rights. And in pursuance of this specific feature, several laws were passed by the legislature, and among those laws there was a spate of land reform laws. Now, if you remember, at that specific time, right to property was a right under Article 91 of the Constitution. It was very well a fundamental right. And because it was a fundamental right, land reform laws, which wanted to divest, sort of convert large land holdings into smaller land holdings, and so that there is an allocation of land among the landless as well, was considered to be a violation of Article 91F of the Constitution. So in the initial aspect of basic structure doctrine, if you go from Shankari Prasad, Sajjan Singh, Golaknath, and even Keshwanand Bharti, you will find almost all the cases challenging land reform laws. So in the initial half, basic structure doctrine was about reconciling land reform laws with the aspirations of the Constitution, and in the meanwhile determining whether the Parliament can make laws, can finally decide what the Constitution is about. Now, so if we were to summarize or simplify this question in one line, the question would be whether the Parliament has unlimited power to amend the Constitution, right? So So when we are talking about who is the final arbiter of constitution, what does it imply? Either the parliament decide what the constitution is, or the judiciary decide what the constitution is. Now, if we are in favor of giving unlimited power to the parliament to amend the constitution, the parliament, because in India the process of amendment of the constitution is not rigid. Okay, there are only certain aspects of the constitution that actually require ratification by the states. Apart from that, it is basically special majority. And let's say there is a political party that comes into power with majority, it is very easy to amend provisions of the constitution. It is not that difficult to amend the provisions of the constitution. So now, the question that now remains is that whether the power of the parliament to amend the constitution is unlimited or not. Okay. Now, obviously, in all the initial discussions on basic structure doctrine, what we were discussing was that the power of the parliament to amend the constitution, or at least what the state was arguing, is unlimited. It is not subject to any limitation. Now, if you look at Article 368 of the constitution itself, it only provides for the procedure in which amendment has to be made, and it does not anywhere mention that there are any kind of substantive limitations on the power of the parliament to amend the constitution. Now, we are only referring to Article 368 for those of you who were not there in the last class, because the power of amendment is an exercise of constituent power, and the only provisions which confers on the parliament the exercise of constituent power is Article 368. And we had also discussed that how all forms of changes, modifications, or let's say amendment in the constitution are not necessarily constitutional amendments under Article 368. When we are talking about exercise of constituent power, it has to be specifically done under Article 368 of the constitution. Now, so the entire question boils down to one basic question: whether the power of the parliament to amend the constitution is unlimited or not. And ancillary to that question is whether there are any implied limitations on the power of the parliament under Article 368 of the constitution. Now, in the initial stages, what we found was that obviously there was a discussion on whether the parliament can bring or insert certain provisions of the constitution or not, and to what extent parliament can bring about a change. Now, the highlight of this moment is Golaknath judgment. Okay, so Golaknath judgment was important because it expressly, for the first time, not that this implied limitation was not being deliberated by the judiciary. If you look at Shankari Prasad Sajjan Singh, there are instances or traces of, at least you can find in the text that this general development of this argument that power of the parliament under Article 368 must be subject to certain limitation. Now, what Golaknath judgment did was, it actually translated it into a legal proposition and held that when the parliament is exercising power under Article 368 of the Constitution, it is exercising that power subject to Part 3 of the Constitution. Okay, and I'm just clarifying it further. I'll repeat it so that you understand it very clearly. What Golaknath judgment said was that the power of the parliament to amend the constitution is subject to Part 3 of the Constitution. What is Part 3 of the Constitution? That is fundamental rights aspect of the Constitution. Now, therefore, the question that eventually what would happen if you consider Part 3 to be a limitation on Article 368 of the Constitution? It would imply that fundamental rights become immutable, right? And what do I mean by immutable? They become fixed. Because if Part 3 of the Constitution limits the exercise of constituent power of the parliament under Article 368 of the Constitution, that means that the parliament can never ever amend Part 3 of the Constitution. They become fixed. Now, so Golaknath judgment basically held that Part 3 of the Constitution is a limitation on Article 368 of the Constitution. Now, after Golaknath judgment, the struggle between the legislature, executive on one hand and the judiciary intensified further. And it's very interesting to read what was happening not in the courts but outside the courtrooms during the time Golaknath was being heard or Keshwan and Bharti was being heard. Now, there is a very interesting book by T.R. Andhyarjun on Keshwan and Bharti, which completely covers what happened within and without the courtrooms in during Keshwan and Bharti hearing. And it makes for a very interesting read as to what happened post Golaknath judgment. So, post Golaknath judgment, there was this struggle between the judiciary and the executive and legislature on one hand to ensure that Golaknath judgment is overruled. So, attempts were being made by the government in power at that specific time to overrule Golaknath judgment, because if Golaknath judgment remained a law of land for a very long period of time, it would prevent the parliament from bringing in those legislations which it wanted to bring, because and specifically land reform laws, because Article 19(1)(f) at that specific point of time was considered to be a part of fundamental rights, it would automatically mean that any land reform that violates right to property would be struck down. So fundamental rights sort of had a priority over all other forms of rights, and they became immutable and fixed in time. Now, we will also discuss another aspect of what the consequence of Golaknath judgment a little later, but for the timing, let's just concentrate on this, what Golaknath judgment did. Now, I hope you are following what I'm saying. If you are not, just let me know and I'll repeat it again. Now, after this happened, it's a very interesting read as to how judiciary started ensuring that the judges in the Supreme Court would overrule Golaknath and render a judgment in its favor. So we have an interesting account of how a judge who was elevated from the Allahabad High Court to the Supreme Court, in a public speech remarked that I am going to the Supreme Court to overrule Golaknath judgment. And perhaps this is the point of time where in India the struggle between judiciary and executive arose vis-a-vis appointment of judges. So before this, it was more or less a collaborative and a very friendly manner in which judges were being appointed to the Supreme Court. But after these specific judgments, main being bank nationalization case, Golaknath judgment, abolition of privy purse judgment, and subsequently Keshwan and Bharti judgment, that the struggle intensified as to who should have the power to appoint the judges to the judiciary. And that is what led to collegium system. So when we study judiciary, we will study how the judgments on basic structure are a contributory factor for this very contemporary debate even today, that who should appoint the judges. Should judges appoint the judges or should executive appoint the judges? Anyway, so coming back to the discussion in hand, what we found is that post Golaknath judgment, there was a lot of things that were happening outside the courtroom in order to ensure that Golaknath judgment was overruled. Now, eventually, we come to Keshwan and Bharti judgment. If you're following news, you must have heard that the lead petition, that is Keshwan and Bharti, passed away a few days back. Now, in Keshwan and Bharti judgment, you would be interested to know that it was basically a challenge to Kerala Land Reforms Law. So what was being challenged in this case was Kerala Land Reforms Act. But in Keshwan and Bharti judgment, what happened was that the court agreed with Golaknath to an extent, but also overruled Golaknath. Now, what do I mean by that? So, in Keshwan and Bharti case, what the court was saying was that Golaknath judgment is, yes, there is an implied limitation on the power of the parliament to amend the constitution. Now, if you look at Golaknath judgment also, it says that there is some kind of limitation on power of the parliament to amend the constitution. And Keshwan and Bharti case is also saying the same. Yes, there is a limitation. There is a limitation on power of the parliament to amend the constitution. But what is the nature and form of that limitation? That is something where Golaknath judgment and Keshwan and Bharti judgment disagree. Now, according to Golaknath judgment, while it agrees that there is some kind of limitation on power of parliament under Article 368 to amend the constitution, The form of limitation that Golaknath is contemplating is Part 3 of the Constitution, which is a sort of very explicitly mentioned in the Constitution. However, in Keshwan and Bharti case, what the court says that whereas we agree with Golaknath to the extent that there is some limitation on the power of the Parliament to amend the Constitution under Article 368, but that limitation does not come in the form of Part 3 of the Constitution. Rather, that limitation comes in the form of basic structure doctrine. Okay? Now, please try and understand. Now, what are the consequences of maybe subscribing to the Golaknath view or subscribing to the Keshwan and Bharti view? Now, the kind of limitation that Golaknath judgment is talking about is limited in nature, because then we would only be limiting the Constitution or the immutable part of the Constitution to Part 3 of the Constitution. Rest all the aspects of the Constitution may be subject to change. Now, if we were to go by Golaknath judgment, maybe federalism would not feature as something that cannot be changed by through amendment process under Article 368, because federalism as a feature does not feature under Part 3 of the Constitution. Now, that was one of the limitations or the drawbacks of Golaknath judgment, wherein the kind of limitation that it wanted to impose on Article 368 was confined to Part 3 of the Constitution. Now, what Keshwan and Bharti does is it expands the scope of limitation by using a comparatively ambiguous doctrine called basic structure. What it says is that the limitations on the power of the Parliament to amend the Constitution are not just found under Part 3 of the Constitution, but are those essential intrinsic features of the Constitution which define its identity, and without which the identity of the Constitution itself may vanish completely. Now, we discussed this in the last class, that basic structure doctrine is like identity marks. So there are certain specific characteristic features which are very particular to an individual, and without those features, if those features are lost, maybe we say that an individual is completely changed or is a completely new person altogether. Now, in the same manner, there are certain characteristic features of Indian Constitution, and if those characteristic features are lost, we might feel as if the Constitution has completely changed in itself. Now, that's why what we need to understand is that what Keshwan and Bharti judgment did by bringing up basic structure doctrine is that it allowed us to go beyond Part 3 of the Constitution to determine what are those features of the Constitution which are very intrinsic to the Constitution itself and which are identical and integral to the Constitution itself. So that is what basic structure history was about, and I hope this part is clear. Obviously, in the next semester, we will be discussing much more in detail this basic structure because we have amendment as a portion of the syllabus. But for the time being, maybe this would suffice. But anyway, if you have more queries and comments and questions, we can always discuss it in the classroom. Now, the second question that comes to us is, what are the contents of basic structure? And this is where our case material will come in handy. And we need to discuss various aspects of, so in Keshwan and Bharti, all the 7 judges who ruled in favor of implied limitation being read as a part of, as something which is a part of Article 368, refer to different provisions of the Constitution or different aspects of the Constitution which they considered to be immutable or so essential and integral that changing them amounted to changing the Constitution itself. Now, before we go into a detailed, at least a discussion on what are those features of the Constitution which were discussed by all the 7 judges, I would like to just bring your attention to a very interesting point. Now, as I told you, Keshwan and Bharti case, Kerala Land Reforms Act was upheld or was challenged for violating constitutional provisions. Okay, basically that the Kerala Land Reform Act in itself is unconstitutional. However, eventually, in the decision, the Kerala Land Reforms Act was not declared to be unconstitutional. Now, how did that happen? Because while the 7 judges, all the 7 judges said that there are implied limitations on the power of the Parliament to amend the Constitution under Article 368, So today when we read limitations on under Article 368, we look at procedural limitation as well as substantive limitation. The substantive limitation is something which we today known as basic structure. Now out of those 7 judges, and the remaining 6 judges obviously said that there is no implied limitation on the power of the parliament to amend the constitution, and the parliament has unlimited power to amend the constitution. And the judiciary cannot read any form of implied limitation on the specific power of the parliament. So what we find is that 6 judges are automatically saying that parliament can pass any law, okay, and none of the law that is passed would be considered to be a violation of the constitutional provisions. However, so 6 judges are already in favor of upholding Kerala Land Reforms Act.
Ma'am, your voice is not clear. We can't hear you at all. No, none of us can. Ma'am, it's still not audible. It's not clear. Ma'am, it's not clear. We are unable to hear you, ma'am.
Okay, now,
You are audible. Yes.
Okay. Okay, fine. Thank you. Yes, what we were discussing was that what is it that Keshwan and Bharti said? That it talked about certain kind of implied limitations, and we were discussing that a very interesting aspect of Keshwan and Bharti. Now, as we all know, that Kerala land reforms law was being challenged in Keshwan and Bharti, right? Now, in the process of challenging this Kerala Land Reforms Act, eventually, despite the fact that Keshwan and Bharti by majority, 7-6 majority, which is a very thin, just on the verge of it was just there, sort of a majority. The court held that there are certain implied limitations on the power of the parliament to amend the constitution. Nevertheless, what we find is that in the final decision, Kerala Land Reform Act was upheld. Now, why did that happen? Because 6 judges, as we all know, were in favor of giving unlimited power to the parliament to amend the constitution under Article 368. Now, while 6 judges were already in favor of upholding Kerala Land Reforms Act. They were not willing to go into the constitutionality because they felt that Parliament has unlimited power to amend the constitution. But what about? But out of those 7 judges who were in favor of reading implied limitation on the constitution, one judge, that is Justice H.R. Khanna, held that right to property is not a part of basic structure. And because it was held by Justice Khanna that right to property is not a part of basic structure, eventually we ended up upholding Kerala Land Reforms Law in Keshwan and Bharti judgment. So, what is important, Keshwan and Bharti judgment, please don't confuse that just because Kerala Land Reform Law was challenged and we came up with basic structure in Keshwan and Bharti, it automatically implies that Kerala Land Reform Act was declared to be unconstitutional. No, that did not happen. Rather, Kerala Land Reform Act was upheld. The only important aspect of Keshwan and Bharti being that it upheld something, it introduced something called basic structure. Basic structure meaning implied limitation on the power of the parliament. Now, what did this advent of basic structure doctrine do? It made the judiciary the final arbiter of constitution. Now, because of this basic structure doctrine, it was the judiciary who was determining what is going to be the content of that basic structure. So now, unlike before, when there were arguments being made, at least in Constituent Assembly, that judiciary should not be given too much power of judicial review. What we eventually end up having is judiciary determining the contents of basic structure and judiciary becoming the final arbiter of the constitution. So that is the importance of basic structure. Obviously, there are several critiques of basic structure. One of the critique obviously being like, and I think some of you pointed it out in the beginning itself, that who is going to limit the power of the judiciary itself? Because while basic structure was introduced as a limitation on the power of the parliament, it ended up giving unlimited power to the judiciary to determine what the constitution is. And what is it? How are we going to limit this power of the judiciary itself? Because power anywhere found has a tendency to corrupt. So how do we limit the power of the judiciary itself? So obviously those are all valid critiques, but for the time being, as a principle of law, we have this basic structure doctrine, and this basic structure doctrine makes judiciary the final arbiter of constitution. Now, having said so, let's just briefly come to Keshwan and Bharti. Okay, what I'll try to do is I'll try to share the screen with you so that you can, because I think many of you would not have the case material. The previous year case materials are there, and at least with regard to this case, there is not much of a change that has happened. But still, just so that you can have a look at what is in Keshwan and Bharti. Just give me 1 second to present. There. Okay, I hope you can see the screen. I'll just enlarge it a little. Okay. Now look at Keshwan and Bharti. It's a 13-judge bench decision. Okay. Now, let's have a look at what Justice Sikri is discussing and how he determines what are the important aspects of Keshwanand Bharti, of basic structure doctrine. Now, what he says is, and I hope this is visible to you, and I'll just read it out also, this paragraph 302, that the judge is not agreeing to the fact that every provision of the Constitution is essential, because otherwise that would imply that the Constitution cannot be amended at all. But as we all know, our Constitution is both flexible and rigid in nature. So the amendment process is a part of the Constitution is flexible and a part of the Constitution is rigid. That it automatically implies that all aspects of Constitution, though important, are not essential per se. So what is the important aspect of the Constitution is that every provision of the Constitution can be amended, provided in the result the basic structure and foundation of the Constitution remains the same. Now, I told you that power of the Parliament to amend the Constitution can be exercised on all parts of the Constitution. So even Part 3 of the Constitution. So even fundamental rights can be amended by the Constitution, right? However, what cannot be amended are the basic structure of the Constitution. Now, according to Justice Sikri, the basic structure of the Constitution is supremacy of the Constitution, republican and democratic forms of Constitution, secular character of Constitution, separation of power, and federal character of the Constitution. So according to Justice Sikri, these are the contents which he identified as basic structure of the Constitution. And this cannot be amended. So while you can bring about changes in those provisions that talk about federal relationship, but you cannot convert of the federal form of Constitution into a unitary form. So tomorrow there cannot be an abolition of 7th schedule. That there are no lists, the power to frame laws solely resides with the Union. That would impinge on federal character. But you may definitely bring an amendment in the 7th schedule wherein you are transferring certain subject matters of list 1 to list 2 or list 2 to list 3 or so on. So those amendments can definitely be brought about, but you cannot bring about a change and let's say that from now on state legislatures themselves stand abolished. States are not going to pass any law. The law will only be passed in the parliament by the union government, and not by the state governments. So that is something that cannot be done. But apart from that, obviously you can say, so tomorrow you can say that this specific subject matter, which is initially a part of list 1, would now be shifted to list 2 or list 2 to list 3 or so on. That can be done. That form of amendment is allowed. So I hope you understand that. Similarly, separation of power between legislature, executive and judiciary. Now, in India, as you will know that we form a parliamentary form of democracy. Okay, and this is very important to understand. So, in India, the separation of power is not strictly compartmentalized. Okay. Now, the reason being that we are a parliamentary form of democracy, not a presidential form of democracy. Can anyone tell the difference between parliamentary and presidential form of democracy? How does parliamentary democracy look at separation of power and how does presidential democracy look at separation of power? Can anyone comment?
Not in presidential form of democracy, there is a watertight separation. Whereas in parliamentary democracy,
yes, in parliamentary democracy, okay. I could not hear you. Anyway, so what you are right in the sense that in presidential, when we are talking about, okay. Yes, Akash, yes. Executives are part of legislature, right? So you are right when we say that in parliamentary democracy, you have an overlap between the executive and the legislature, and we are following a parliamentary model of democracy. So what we find is that the personnel, personnel, meaning members of the executive are also members of the legislature and members of the legislature are also members of the executive. That is Council of Ministers. So Council of Ministers are per se headed by the Prime Minister, obviously. are per se members of the executive, right? They were from the executive wing of the government. But all these council of ministers also have to be members of either the legislature itself. So that is either the upper house or the lower house. In case of center, it would be Rajya Sabha and Lok Sabha. In case of state, it would be Vidhan Sabha or Vidhan Parishad. In case it is a bicameral legislation, if it is unicameral, then obviously Vidhan Sabha. So members of the executive are also members of the legislature. So what you find is that the council of ministers are overlapping. There is a personnel overlap between members of between the executive and the judiciary. Now, on the other hand, in a presidential form of democracy, what you will find is that judiciary, executive, and the legislature are completely separate. That which happens in the United States, for example, wherein executive is completely separate, judiciary is completely separate, and the legislature is completely separate. So there is no personnel overlap between executive and legislature. That does not mean that India does not have a separation of power. Okay. Today, when we understand separation of power, because you have studied separation of power in your first semester, so you may have a brief idea of what separation of power is about. We do not strictly follow the Montesquieu principle of separation of power, wherein he talked about strict compartmentalization of power. So, as was mentioned by one of you right now, that it is not about strict compartmentalization of power. Rather, separation of power has to be understood as a process of checks and balances, wherein power of one wing of the government is sort of balanced by the other wing of the government. So that is why. So, for example, in the United States, you will find Congress, which has the sole power to legislate. Okay. And the president obviously is separate completely. That is the presidential form of democracy, wherein we are having strict separation of power. But there is a parliamentary form of democracy, wherein we are not having per se strict watertight compartmentalization, but there is some kind of personnel overlap in parliamentary democracy. And if you look at Article 50 of the Constitution, which is obviously a part of directive principles of the state policy, one of the directive principles which has been given under Article 50 of the Constitution talks about separation of power between the judiciary and the executive. It does not talk about separation of power between the legislature and the executive, because that is something which parliamentary form of democracy, at least with respect to certain aspects, there cannot be strict watertight compartmentalization between the executive and the legislature. That is right. But however, that does not mean that there is no separation of power. When council of ministers are part of the executive, they are functioning in different capacity, and when they are part of the legislature, they are functioning in a different capacity. They serve as a bridge between the legislature and the executive. So that is how we have to understand separation of power in India. But having said so, separation of power is an intrinsic feature of the Constitution. So tomorrow, a law cannot be passed which in any manner completely denigrates or abrogates this concept of separation of power. Third being secular character of the Constitution. Republican and democratic forms of the Constitution. What is Republican and what is democratic? Can anyone explain? What do you mean by Republican?
Ma'am, in Republican form of government, any citizen can hold the position of head of the state.
Okay, right. Yeah. So are republic and democracy one and the same term? Can they be used interchangeably?
No, ma'am, because Britain is a constitutional monarch, but still there is a democracy.
Yeah, right. I think very, very good. So what we mean to say by Republican form of government is basically that the head of the state is elected, okay? And the form of election can be direct or indirect. For example, in India, it is indirect election. In Constituent Assembly, we would be interested to know that what was contemplated was that whether apart from the representatives of the legislature, president should be also directly elected by the people. Now, what was argued was that if the prime minister is also directly elected by the people, and the president is also directly elected by the people, there would be two equal centers of power, both of them competing, both of them being both of them being elected by the will of the people, and that's why it might create two centers of power. In order to avoid that, what was done was that the procedure of presidential election was made indirect in India, but obviously the Council of Ministers or the legislature was elected. Members of the legislature were elected directly, and thereby the head of the state, the de facto head of the government, that is the Prime Minister, was also elected directly. So yes, you are correct in saying that in Republican form of government, the head of the state, the person in whose name the government is carried out, is elected. But democracy is not about that. Democracy is about wherein the representatives of the government are elected by the people. The head of the state may or may not be elected by the people. And as you correctly pointed out, Britain being an example of a democracy, but not a republic. Because in Britain, the head of the state is being elected, is not elected, is hereditary, is a monarch. So that is democracy, but a monarchy. But we are a democracy. India is a democracy, but a republic. So that is one. And the last is supremacy of the constitution. The constitution and the supremacy of the constitution basically implies that the constitution is going to guide. So no law of the land can actually go against the constitution. So an amendment cannot be made in the constitution to the effect that a specific law of the land will not be subject to the constitution itself. That is something which will not be allowed. So, according to Justice Sikri, those are the basic features of the constitution. Now, the reason I am taking you through at least the reason of inserting these specific excerpts of Keshwan and Bharti in the case material is very simple. Obviously, the whole judgment cannot be put in your case material, first of all. And we are studying basic structure only with a very, very specific perspective in your first semester in order to understand what briefly or in a very, not in a very nuanced or detailed manner, but have a brief idea of what basic structure is. Now, let's come to Justice Chehlath and Justice Grover's opinion. And in Justice Chehlath's and Justice Grover's opinion, there are several aspects of the Constitution which have been highlighted by Justice Chehlath and Justice Grover. And please go through, whenever you get access to case material, please go through these excerpts. I will upload Keshwan and Bharti on your classroom if you want to go through the entire text, and it will be very helpful if you go through the entire text. But at least go through these aspects because these will also tell you about what are the different features of the Constitution. Now, if you look at the first paragraph, and maybe you can see the highlighted portion, it says that what Justice Chehlath and Grover are arguing that Constitution is an organic document which must grow and must take stock of the vast socio-economic problems, particularly of improving the lot of the common man consistent with his dignity and unity of the nation. Now, the focus is on Constitution is an organic document, and this brings us back to the discussion that we were having in one of the previous classes between living Constitution and originalism. So since the very beginning, it would seem that Indian judiciary has interpreted Constitution as a living document, something which is not immutable or fixed in time. And we need not always concede or defer to the opinion of the authors of the Constitution whenever we are interpreting the Constitution. It is very well within the permissive. The Constitution rather allows us to deviate or disagree with what the authors or framers of the Constitution or the reason why specific provision or specific words were inserted in the Constitution. And the Constitution allows for those disagreements. The Constitution allows for those transformations. And it is very much clear in Justice Chehlath and Grover's argument that it's an organic document which must grow with time. Now, this paragraph 503 is very interesting when you read it. Now, and it talks about how different parts of the Constitution were inserted and why were they inserted. And it accepts that obviously a large portion of the Constitution was borrowed from Government of India 1935 Act. But if you look at the Constitution, it is the preamble that embodies the great purpose, objective, and policy underlying it, apart from the basic character of the state that is sovereign, democratic, and republic. And it says that Part 3 and 4, which embody the fundamental rights and directive principles, have been described as the conscience of the Constitution. So we find Mrs. Chelat and Grover sort of implying that Part 3 and Part 4 would be considered to be an essence of the Constitution, but nowhere in the entire Keshwan and Bharti judgment has it been said that the entire Part 3 is a part of basic structure. Obviously, certain parts of Part 3 are a part of basic structure. But to say that the entire Part 3 is a part of basic structure, it is immutable and fixed, is something which Keshwan and Bharti did not agree to. What was said was that entire scheme of Constitution is such that it ensures the secure sovereignty and integrity of the country as a republic and the democratic way of life by parliamentary institutions based on free and fair elections. So this was considered to be something which is very intrinsic to the idea of Constitution of India. Now, Justice Hegde and Justice Mukherjee clarify another very important aspect of Article 368 and what the Constitution is about. And this is where that discussion is being made as to what is basic structure. It is those identity marks of the Constitution, right? So what they say is that we cannot legally use the Constitution to destroy the Constitution itself. So the power which has been vested on the Parliament by the Constitution cannot be used by the Parliament to destroy the Constitution itself. Now, what they're saying is that under 368, the amended Constitution must remain the Constitution, which means the original Constitution. Now, that does not at all mean that the original Constitutions cannot be changed, but it is rather the essence, the substance of the Constitution that cannot be changed. So, what they are saying is that while certain provisions of the Constitution may be abrogated or repealed, we are only talking about the form, but the substance of that Constitution cannot be changed. And if any of the basic features of the Constitution is removed such that the substance of the Constitution is abrogated or repealed, then it would amount to formulation of an enactment of a new Constitution. And that is something which cannot be allowed. So the substance of the original Constitution must persist over a period of time. What cannot be changed, however, is what can be changed is the form of the Constitution, but not the substance. And that substance is the basic structure of the Constitution. So that is what Justice Hegde and Mukherjee are talking about. Now, similarly, if you look at now, the reason why these different excerpts are given, obviously each of these judges talked about basic structure very much in detail, but all these different excerpts will indicate towards certain characteristic feature of the Constitution. Now, Justice Palekar's excerpt in the case material basically talks about the flexible and rigid aspect of the Constitution. Now, Indian Constitution, the amendment process is both flexible and rigid. Now, the most rigid form of an amendment process of the Constitution would be, can anyone comment? What would be, if we were to say that, what is the most rigid form of amendment process that you can think of? Anyone?
Ratification by states.
Oh, okay, still, but much more difficult than that.
Ma'am, as in US, 3/4. As in US, we have 3/4.
Okay, fine. But yeah, that is a rigid aspect. At least in India, for example, you also require ratification by the state in certain aspects. Rigid aspect, but much more rigid would be if the Constitution could only be amended by a referendum process. Can you contemplate of a situation where the only manner in which you can amend a Constitution if you carry out a referendum? That this is the amendment that we want to bring, and all the citizens of the country are voting whether that amendment has to be done or not. So that is the most rigid form of amendment process. And that is something that India does not have. Now, with regard to what you said, ratification by the state. Yes, ratification by the state provides rigidity to the amendment process, because then amending does not become that easier. Then the government, if it is government who is exciting or is enjoying majority in the parliament, would not automatically be able to bring about change in the Constitution. It would require ratification by the states, and the states may have different governments themselves. So that is a rigid part. At least in India, that is the rigid, but that is not the most rigid aspect of amending process. The most rigid manner of amending Constitution that we can contemplate of it may be the referendum, which is something which is not a part of India. But yes, Article 368, if you look at Article 368, it has a flexible as well as a rigid element. The Indian Constitution is that considered to be both flexible and rigid. It is flexible because there are certain provisions of the Constitution which can be amended, okay, by a special majority. There are certain provisions of the Constitution which are not even an exercise of constituent power under Article 368. They can be amended by ordinary majority. So, example that we took was Schedule 5, Schedule 1, Schedule 2, Schedule 4, Schedule 5. All these are different parts of the Constitution which can be amended by the exercise of ordinary majority, because such amendments are not considered constitutional amendments under Article 368. But apart from that, if you come to Article 368, there are different hierarchies of rigidity or flexibility. So the second would be amendment by a special majority, wherein more than 50% of the membership of the total House plus 2/3 of the members present and voting are voted in favor of the amendment in both the houses of the Parliament. Okay, so it is not that easy, because both of the houses of the Parliament have to approve that specific amendment, but still comparatively easy as compared to requiring ratification by the state. And the third level of rigidity or flexibility is when you require an amendment to be ratified by more than 50% of the state. And what are those aspects which require ratification by the state is found under Article 368 Clause 2 provides so. And most of them deal with distribution of power between state and the union. So, yes, so that's why Justice Palikar's excerpt in your case material will bring your attention to the fact that Constitution is both a rigid as well as a flexible document. Now, is the Constitution, now, there is a very interesting term that has been used by Justice Palikar, that about whether the Constitution is a controlled Constitution or is an uncontrolled Constitution. Now, the manner in which controlled and uncontrolled were used, at least how Justice Palikar is analyzing or explaining this term, is that controlled was used vis-a-vis rigid constitution and uncontrolled was used vis-a-vis flexible constitution. Now, in India, what we have done is we have sort of balanced. It is not an uncontrolled constitution, obviously, because the limitation on the Parliament to amend the constitution is subject to certain forms of limitations and control. However, those limitations and control are not extremely rigid in nature. Rather, there are different hierarchies of flexibility with which you can amend the constitution, and that is something which Justice Palikar's opinion wants to draw our attention to. So that is the opinion of Justice Palikar, and let's then come to Justice Khanna's opinion. Now, Justice Khanna's opinion, again, very much like the opinion of Justice Sikri, looks at Constitution as a living document, as something which is necessary to be the vehicle of the life of nation, and that Constitution is not the goal in itself, but is merely a journey to a specific goal. And that the Constitution must be interpreted in a manner that helps us meet our aspirations in the best possible manner. So that is what Justice Khanna is talking about. So, for example, let's look at this portion. That Constitution reflects the hopes and aspirations of the people. Besides laying down the norms for functioning of different organs, a Constitution encompasses within itself the broader indications as to how the nation is to march forward in time. A Constitution cannot be regarded as a merely legal document to be read as will or an agreement, nor is a Constitution a plain or written statement filed in a suit between two litigants. It must be the necessity be the vehicle of the life of a nation, and that Constitution is not a gate but a road. Okay? So that is how Justice Khanna has understood the Constitution, or discussed what the Constitution is. And Justice K.K. Matthew, very much in line with the idea of living Constitution, considers the Constitution to be Darwinian in structure in nature. So if you see this portion, that a living Constitution must be Darwinian in structure in nature, that is by Darwin, obviously we are referring to Darwin's theory of evolution, that Constitution must evolve over a period of time. It cannot remain redundant and stagnant. Right? So this is how different aspects of the Constitution were discussed in Keshwanand Bharti case. Obviously, there is a lot more to Keshwanand Bharti case than these excerpts which are found in your case material. But again, as I said, as per the requirement of your syllabus, let's just stick to this much. And if we get time after the syllabus is finished, we will discuss basic structure, because it's a very interesting discussion. A very interesting aspect of constitutional law, basic structure law. Okay, so we will stop here, and there is another judgment that has been inserted in your case material this year, that is 9th schedule, IR Coelho judgment. So we will also discuss IR Coelho judgment and maybe then wrap up our discussion on basic structure. In case you have any questions, queries, comments, we can discuss it tomorrow. Now, this is something that we discussed briefly in the last class as well, and we'll be continuing with the same discussion. So just briefly to summarize what is basic structure about. We discussed several aspects of basic structure. The first being, why is it that basic structure doctrine evolved, and what led to the development of basic structure doctrine in India. As we discussed in the last class, basic structure doctrine is primarily about determining the one important question, that is, who is going to be the final arbiter of constitution? Who is it who will decide, which wing of the government will decide what the constitution is about? Now, I gave you the example of the discussion on Article 21 of the Constitution in the last class. And we discussed that how, when there was a discussion going on with reference to Article 21, and specifically with regard to whether the term procedure established by law should be used under 21 or due process of law, the Constituent Assembly members seemed to argue that we are not going to insert due process of law under Article 21, because that would amount to giving judiciary the power to review all the actions of legislature and the executive. And the primary power to determine what the law, what the constitution is, must reside with the parliament per se, or with the legislature, and not with the judiciary. And that is why the text of the Article 21 that we have in the Constitution features the term procedure established by law and not due process of law. Now, obviously, subsequently, over a period of time, Menka Gandhi versus Union of India being the highlight moment, watershed moment, wherein there was sort of a complete disjunct from how Article 21 was and why Article 21 was inserted under the Constitution by the Constituent Assembly. And what Menka Gandhi case argued or held was that Article 21 talks about due process, and it is not just procedure established by law. But the only reason why this example we discussed in the last class was in order to understand that since the process of formulation of constitution itself started, we were discussing this very core issue about who should be the final arbiter of power, whether it should be the judiciary or it should be the parliament per se. And the Constituent Assembly seemed to tilt in the favor of not of vesting this power with the parliament instead of with the judiciary. So eventually, over a period of time, as we discussed in the last class, a series of specifically different laws were being passed by the state. Now, that those laws were made with different intentions. Some of the provisions and amendments were also made to the Constitution. One of the amendments being that in case.
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा। कमेंट बॉक्स में अपना फीडबैक देना ना भूलें। थैंक्स फॉर वॉचिंग।